Madame Drouin. Madame Drouin.
Bonjour, j'aimerais remercier.
Hello, I'd like to thank members of the committee for allowing me to make this opening statement. My opening remarks will address my role and responsibilities as Deputy Minister of Justice and Deputy Attorney General of Canada, my professional relationship with the Honourable Jody Wilson-Raybould, and my chronology of events. As Deputy Minister of Justice and Deputy AG of Canada, I support the Minister of Justice and Attorney General and the government in the development of their policy objectives. In the exercise of my duties, my vision has always been the provision of high-value legal services. Given the traditional role of jurists, I would ask you to I always have a strategic alliance with customers, working as partners, focused on finding solutions and delivering results.
Of working with highly competent and impressive individuals. The former Minister and Attorney General and I had a very positive working relationship. I commend her for what she brought and brings to Canada in her role in public office. I can tell you that I learned very much and a lot working with her, especially in terms of Indigenous issues and lawmaking. In fact, we continue the work she began at Justice Canada by taking a new approach to Indigenous litigation. I hold myself and my staff to the highest standards of providing nonpartisan advice. My role is supporting the ministers and Attorney General demands that I uphold the values and ethics expected of me, both as a public servant and as a lawyer. I would like to begin by describing my dual role as a Deputy Minister of Justice and Deputy Attorney General. I have been in this position since June 2017. In both these roles, I support the Minister of Justice in fulfilling his or her responsibility. My functions include giving legal advice and coordinating the legal advice given by the Department of Justice, supporting the development of legislation and policy that fall within the justice portfolio, as well as acting as the formal representative of the Crown in all civil litigation involving the Government of Canada. In addition to my support, the Attorney General of Canada is also supported by the Director of Public Prosecutions, who is also a Deputy Attorney General of Canada. The DPP and I do not report to each other. It is not my role to discuss specific prosecutions with her, and I have not discussed the substance of the SNC-Lavalin prosecution with her. However, I do provide advice to the Attorney General of Canada in her or his decision-making as to whether or not to issue directives to the Director of Public Prosecution or to assume the conduct of a federal criminal prosecution. In such situation, I approach giving legal advice in the same way I would when giving advice on any other statute, but with careful attention to the distinction between my job and the job of the DPP. Monsieur le Président,
Chair, by the scope of the Order in Council that was enacted by the Governor-General in Council on February 25th, 2019, I would now like to provide the committee with a detailed account of my interactions on this file. In order to provide you with this account to the best of my ability, I have reviewed my emails, files, and agenda. I have not consulted Ms. Wilson-Raybould, the Minister Lametti, or their staff, or anyone outside of the department on facts that are my own. My account will include details of the discussions that I had with the former Attorney General respecting the exercise of her authority pursuant to the Director of Public Prosecutions Act. September 4th. On September 4th, the department became aware of the director's position to continue with the prosecution of SNC-Lavalin. I would like to clarify that on that I still don't know how or when the director's position was shared with SNC-Lavalin. On September 5th, as I mentioned, I have reviewed my calendar to my best ability. My calendar indicates that on September 5th, I had a phone conversation with Paul Rochon, Deputy Minister of Finance. However, I cannot recall whether we talked about this file, another file, or both. Moreover, from what I can recall, that a first discussion that I had with Ms. Wilson-Raybould on this file was on September 5th, late in the afternoon. The purpose of the call was to discuss another file, but from what I recall, SNC was also discussed on the margins. The former Attorney General was in Fiji, and there was a 17-hour time difference. Two of her staff members, Jessica Prince, Chief of Staff, and Emma Carver, Policy Advisor, joined the call. We agreed that the department would provide advice on the role of the Attorney General for her consideration. I told them that the department had begun working on the advice the evening before.
For the 2 next days, my official and I developed a written advice. I also provided verbal advice to the AG staff, Emma Carver and François Giroux, on the Attorney General's power under the Director of Public Prosecution Act. I advised that it would be very important for the Attorney General to be comfortable with the Director position to not pursue a remediation agreement. I emphasized that the Attorney General was entitled to receive as much information as she considered necessary from the Director. It was during the course of these conversations with Emma Carver and François Giroux that they read to me the extract of the Section 13 letter from the DPP. For clarity, a Section 13 letter from a DPP to the Attorney General is to inform the Attorney General in a timely manner of any prosecution or intervention that the DPP intends to make that raises important questions of general interest. As I have explained to the committee, in fulfilling my role as Deputy AG, I am very careful to separate my role and responsibility from that of my counterpart, the Director of Public Prosecutions. As I have mentioned, I have no role in specific criminal prosecution and am not privy to any of the evidence. This is why I refuse to review and receive the Section 13 letter. It was during the same conversation that Emma Carver informed me that she was drafting a document that she intended to provide to her counterparts at the Prime Minister office. I was also told that the Attorney General was not keen on the idea of exercising her authorities under the DPP Act. In her testimony, the former minister mentioned that I had conveyed information from the Department of Finance. To clarify, on September 7, I spoke with the Deputy Minister of Finance, Paul Rochon, and he had questions regarding the decision-making process and the roles and relationship of the AG and the Director of Public Prosecutions. Also, on September 7, I spoke to the former Attorney General's Chief of Staff and provided her a verbal outline of what we were drafting for the AG's consideration. On September 8, I provided a draft opinion to the former AG's office. The opinion is entitled, "The Power of the Attorney General to Issue Directives and to Assume Conduct of Proceedings." Sorry. The opinion begins with a discussion of the Attorney General's independence and her ultimate responsibility for criminal prosecutions. It describes the role of the DPP in much the same way I have explained to this committee. It also describes the power to assume conduct of a prosecution and the power to issue directive. The opinion also provides advice to the AG on the role of the DPP and that the AG is entitled to receive information from the DPP in order to understand the decision. Various options are set out in the situation where the AG either disagrees with the director's position or wishes to further assess the decision. These options include the issuance of directives that direct reconsideration or appoint a specific prosecutor to reassess. Another option covered is for the AG to decide to assume conduct of a prosecution, consider whether statutory conditions for remediation agreement are met, and if so, appoint an agent to negotiate such an agreement. The legal opinion also canvasses the possibility of seeking outside advice with respect to the AG's power under the Act and the Criminal Code in order to assess whether the conditions for a remediation agreement are met. The legal opinion advises that the relevant constitutional and statutory framework prioritize independence and transparency, and that any decision by the AG is hers to make, independent of the political consideration or processes. There is also a short discussion of the deference by courts to prosecutorial discretion, which can be reviewed only for abuse of process. Je voudrais apporter un peu de contexte.
I would like to provide some context on this part of my remarks. While I have been at Justice Canada for almost 3 years, as you know, I also worked in Quebec in similar roles. During that time, I gained expertise in this area as I faced similar situations where decisions of a DPCP were publicly challenged and where an Attorney General was called upon to act. I appropriately brought this professional experience and expertise to bear on the advice my department provided to the Attorney General in this matter. September 10th. The department responded to 2 follow-up questions that we had received from the Attorney General's office as a result of the draft advice. On September 11th, the Attorney General's acting Chief of Staff, François Giroux, informed me by email that the Attorney General was not intending to intervene in the case and that she would be pleased to discuss it. On September 12th, the next day, the Department of Finance indicated to me that SNC-Lavalin was still in discussions with the DPP. I therefore understood that the DPP's position on whether to invite SNC to negotiate a remediation agreement was not final.
Or 19, and I would like to be more precise, but I don't have any evidence on that. I have a discussion occur with the clerk on the margin of a weekly meeting that we call the DM breakfast. I recall that I had a discussion with the clerk where we discussed options that the AG had available to her role, the DPP's roles, as well as my role. On September 16, I had a call with PCO where we would have discussed also the advice of the AG. To the best of my recollection, my first face-to-face meeting with the former Attorney General on this file was September 17, and I believe we may have only briefly discussed it on the margin of another meeting. I also saw the minister on September 18 and 19. On September 18, the only purpose of the meeting was for the minister to debrief on her meeting the day before with the Prime Minister. I do not recall her specific words, but I remember her telling me that the clerk was present. She also expressed to me that she was not comfortable with the content of this conversation. September 19. During my bilat on the afternoon of September 19 with the former AG, she told me that she just had a discussion with the clerk. During the same meeting, I clearly recall that the former AG said to me that this would be the last time we discussed the SNC-Lavalin matter, and she also instructed me not to have any discussion with the DPP. To the best of my knowledge, and to be clear, after September 19, I did not have any further involvement on this file with the minister and her staff, with 2 exceptions. Je tiens à préciser qu'au meilleur de mes souvenirs,
I'd like to specify that to the best of my memory, my last contact with members on this file was September 19th, with 2 exceptions. The first of the exceptions occurred on October 19th when the application for judicial review of the DPP's decision was filed with the federal court. As would be regular process where there's an application for judicial review, officials in my department discussed with the DPP who should appear on behalf of the Crown. The second exception occurred near the end of the month of October. I do not have the exact date. The Privy Council Office asked my department for an opinion on the potential impacts on SNC-Lavalin if the prosecution were to result in a criminal conviction. My department developed the draft legal advice. It was not provided to PCO at the request of the Minister's Office.
In my chronology, I would like to return briefly to the time I first became aware of the January 14 shuffle. And again, I would like to, for the record, to say that I haven't discussed this testimony with the clerk. On Friday, January 11, the clerk of the Privy Council called to inform me of the upcoming shuffle. I was not told who the new minister would be. I proactively asked the clerk what areas or files I should be preparing to brief on for the new minister. The clerk identified briefings the new minister and Attorney General on roles and responsibility as the primary need. This indicated to me that we were going to be receiving a first-time minister. The clerk also recommended that I brief the new minister on Indigenous files because the Prime Minister could ask the new minister to attend a meeting with Indigenous organizations early next week. He also recommended briefing the minister on current issue, including remediation agreement and SNC. As you are aware, SNC-Lavalin has sought a judicial review and the DPP decision, so it was a live issue for the new minister to be made aware of. To brief the new minister, I developed, with the assistance of my immediate team, a briefing handbook, which I am tabling here today. And je pense que vous avez les documents.
I think you do have the documents in French and in English.
In the handbook that the remediation agreement is also included. It was in this context that on the afternoon of January 11th, I informed Jessica Prince, whom I thought was remaining the Chief of Staff, that we will need to brief the new minister on. Je vous remercie pour votre
Thank you for your attention. I know I went over my time a little bit, but I'm now prepared to answer your questions. Thank you very much for your testimony. I'd like to thank both of